Morning, everybody. As part of our journey to unravel the intricacies of the Constitution, which are misunderstood, misinterpreted, and misapplied by various constitutional agencies in this country for the last 75 years, we have discussed right from the preamble to Article 16 till day before yesterday. Today I am supposed to discuss Article 17, 18 and 19. But on 13th August 2025, I have seen the news items that Hon'ble Supreme Court has cancelled the appointment of MLCs of two Congress candidates, namely Kodandaram and one Amir Ali Khan. That subject is related to Article 171 and 163. But if I wait until we reach Article 171, the matter loses importance. And that matter is very, very important to this country. And especially only for such things I have started this web series to unravel the secrets of the Constitution. In 2023, BRS party in Telangana have suggested firstly the name of some party Kaushik Reddy to the MLC, and later they referred names of one Sravan and K Satyanarayana for appointment as MLCs under 171 Article Clause 5 by the Governor of Telangana, Her Excellency Mrs. Tamilisai Soundararajan. She refused the candidatures of Sravan and Satyanarayana. Later, Congress has come to power in the state of Telangana and recommended the names of Kodandaram and Amir Ali Khan. She has accepted and appointed them as MLCs. Sravan and Satyanarayana went and filed writ petitions in the Honorable High Court for the state of Telangana, which said that the decisions of the governor were invalid, whereby they too were disqualified. They went in appeal to the Honorable Supreme Court, which allowed Kodandaram and Mir Ali Khan to take oaths of office. However, on 13th August 2025, the Honorable Supreme Court realized that it was a mistake, since they said Kodandaram and Mir Ali Khan have not preferred any appeal, neither they have filed any petition before the Honorable High Court for the state of Telangana. Hence, their nominations were cancelled, and final judgment, of course, was posted to 17th September or so. The constitutional questions which arise in this issue are whether the Chief Minister or the Council of Ministers have the power to recommend names to the Governor of that state for appointment as MLCs under the Governor's quota. The second question is whether the Governor of that state is bound by the advice of the Council of Ministers to appoint members of Legislative Council in the Governor's quota. And now the question arises whether judiciary has power to interfere with this process. These are the three very important constitutional questions that arise from this transaction. In my opinion, To answer to all these three questions is a stern no. The Council of Ministers is not entitled to recommend names to the Governor for appointment as members of Legislative Council, because Article 171 Clause 3 clearly says how many council members should be appointed by which section of the public representatives. It says that 1/3 of the members shall be elected by the local bodies and 1/3 shall be elected by the MLAs and 1/12 shall be appointed by the graduates and another 1/12 shall be appointed by the teachers. So there remain another 1/6 of the members. We know in any legislative council a minimum membership is 40 and a maximum it can be up to 1/3 of the membership of the legislative assembly. So the remainder is to be appointed by the governor of that state under clause 5. So the teachers appoint their representatives, the graduates elect their representative, and MLAs appoint their representatives, and local bodies elect their representative, and the remaining is governor's quota. Is it reasonable that the governor's quota also should be filled by the chief minister and his council of ministers? If this were to be so, the constitution should have not provided for governor's quota at all, or it should have said that governor's quota shall also be filled in accordance with the advice or recommendation of the council of ministers. The governor has to appoint such of the persons who are experts in literature, science, art, cooperative movement and social service. Thus, governor has to use his discretion to examine whether the proposed candidates have such characteristics or not, whether that qualifications or not they are having. Now let us see whether the governor should accept the recommendation of the Council of Ministers. Article 163 says that there shall be Council of Ministers with Chief Minister as head to aid and advise the governor in executing his functions as governor. The rider is except in so far as he is by or under the Constitution required to exercise his functions or any of them in his discretion. That means there shall be Council of Ministers to aid and advise the governor only in such functions which do not require the individual discretion of the governor. Where his discretion is necessary, Council of Ministers are not empowered to advise him. And Article 163 Clause 2 clarifies it further that if any question arises, whether any matter is or is not a matter in respect of which the governor is by or under this constitution required to act in his discretion, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion. So the Council of Ministers are not entitled to advise the governor in matters which require his own discretion. And when the governor acts, it is after all his decision to act in his discretion or to act on the advice of the Council of Ministers. And his decision shall not be called in question, whether he acted in his discretion or on the advice of the Council of Ministers. And 163.3 specifically says that what advice was tendered by the Council of Ministers shall not be inquired into by any court. So, by explicit provisions of Article 163, 1, 2 and 3, Governor is not bound by the advice of the Council of Ministers in matters which he require his discretion. And again, which matters require his discretion is also his choice, and it cannot be inquired into by any court of law. Article 166.1 also says that the governor allots departments to various ministers. He allots various duties to various ministers. In doing so, he is not supposed to delegate such of the functions which require his own discretion. So even if the governor wants also, he cannot delegate his discretionary powers to the ministers. Unfortunately, the whole country is under the wrong impression that the executive is bound by the advice of the Council of Ministers. It was only in 1976 through 42nd Amendment that Congress Party introduced the amendment to the effect that the President of India is bound by the advice of the Council of Ministers. It was an amendment to Article 74. So please understand that when it was introduced in 1976 through 42nd amendment, such a condition was not there in the original constitution. In fact, it is the feature of Pakistan Constitution of 1973, Article 48. Pakistan Constitution Article 48 says that the President is bound by the advice of the Council of Ministers, of which the Prime Minister shall be a part. Unfortunately, the same thing has entered Indian Constitution in 1976 through 42nd Amendment. You see the fallacy of this wording. I say all powers are yours, but you have to act according to my advice. That means you do not have any powers whatsoever except following or obeying my advice as my servant. So master has become servant, servant has become master. This is the misfortune of 140 crore people of this country. This is an insult to language. How any advice can ever become a command or order for his superiors, especially the persons who are giving advice or subordinates, and we are saying that this advice is order for their superior. It is an insult for the language and for those people who believe it to be a legal statement. And moreover, that amendment was made to Article 74. Did it ever say that the same amendment shall also apply to Article 163? No. I'll bring one more article to your notice, that is Article 167, which said that it shall be the duty of the Chief Minister. Duty. Duty means inescapable, unavoidable condition. It is the duty of the Chief Minister to report to the Governor all administrative and legislative proposals and to furnish further information as may be sought by the Governor. So the Governor may seek information. The Chief Minister is bound to furnish such information. And the Chief Minister is bound to report. Please understand the word report. Who reports to whom? The subordinates report to their superior. Despite that, unfortunately, a widespread misunderstanding is prevalent in India that the President and Governors are bound by the advice of the Council of Ministers. We have covered that ministers do not have authority to recommend names to the governor for appointment as MLCs. And we have also decided that the governor is not bound by the recommendations of the Council of Ministers. And now let us consider whether judiciary can interfere with this process. Of late we have seen, in case of defection of MLAs and their disqualification, courts usually hesitate to give directions to the speaker. Please understand, the most important functionaries in the country are the president and the governor. Ministers are their appointed subordinates. If you nullify their powers, it means that you have annihilated the executive. When there is no executive, there is no democracy. Democracy means there should be legislative, executive and judiciary separately. Judiciary, I keep it apart because that is not a political institution, whereas democracy is a political statement. For any country to be democratic, there should be legislative and executive wings separated. If you bring all the executive powers into the hands of the legislative wing, how can it be democracy? It will be autocracy or monarchy. It will be oppressive, undemocratic, unconstitutional. The Constitution specifically intended to keep the judiciary under check of the legislative and the executive. It clearly provided that under Article 122, judiciary is not entitled to interfere with legislative proceedings even if they are irregular. It is also contained in 211 as regards assembly proceedings. The courts are not entitled to interfere with legislative proceedings even if the procedures are wrong. Article 361 provides blanket protection to the president and the governors, that their actions cannot be called in question in a court of law. They cannot be summoned to courts. Does it mean that without calling them, without hearing them, their orders can be struck down? When you are not entitled even to register a case against them or to call them to or summon them to the courts, does it mean that without calling them, without summoning them, we will strike down their orders? This is a misunderstanding of the law. As such, please understand that the Council of Ministers of a State is not entitled to recommend names to the governor for appointment as legislative council members. Number 2, the governor of the state is not bound by the recommendations of the Council of Ministers as regards the matter of appointment of MLCs. An overriding power was given instead to the executive to nullify the judgments of the honorable courts in regard to imposition of punishments. The president and governor are entitled to waive or reduce punishments inflicted by the judiciary under Article 72 and 161. As such, all the three, legislative, executive and judiciary, should function in their given spheres. One should not meddle with the functions of the other. It's not good for the country or for the democracy. Thank you. Thank you for watching my video. I request you to please subscribe, share and comment on my videos, and I will be glad to reply to your comments. Our journey is to unravel the whole constitution video by video. But I will be taking a leave here and there to discuss on current and conflicting topics. Thank you for watching my video.